Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Hey, welcome back to the Just Verdicts podcast. Today I'm super psyched to get to talk with two Western PA stars and friends of mine, John Gismondi and JJ Gismondi from the law offices of John Gismondi. And, it's always an extra special treat for me when I get to talk to other Western Pennsylvania trial lawyers about their verdicts, because I feel like sometimes with all these, the Philly verdicts and these other places, like people forget about Western PA, and we have our own stable of amazing trial lawyers. And JJ, obviously you're an up and coming rising star, but your dad, John here, he has been an attorney that I've looked up to pretty much my entire career. And, John does it all. He's the master of ceremonies for the Academy of Trial Lawyers. He puts on the best CLEs that you could ever be a part of, runs a tremendous firm that's been successful for decades and decades, just highest, ethical sort of, standards, and somebody that, really, John, I'm sure you have no idea how much I've looked up to you over the course of my career. And I'll just leave you with one anecdote, and then you guys can maybe talk about your firm and your practice yourselves a bit. But I was thinking last night about this interview, and I can remember that when my wife and I lived in Shadyside, I used to work out at the fitness factory. And so I would be on the elliptical, and there'd be all these televisions up in front of me. And I was probably 4 or 5 years into my practice. And you had some big case, John, and you were being interviewed on television. And it was like, attorney, John Gismondi, speaking about whatever the case was. And, I was like, man, I would love to be like that one day, just because I'd heard about you. Now you're on TV. And I just remember that moment so kind of poignantly. And then it's been, my good fortune to get to know you better and better over the years. And I sat through a lot of your, was it the trail case when you hit for 22 million?
Yeah.
I sat through a ton of that case. I can remember your opening statement very vividly. So, it's really exciting for me to have you both on the show today. So thanks for being here, both of you.
Well, Brendan, your words, frankly, are too kind. And, that's all I can say. It's too kind, and it's a pleasure to do it. This is an interesting concept you have, and, we're happy to do it.
I really like the father and son duos as well. As a dad of 3 boys, I'm really interested to hear about sort of what it was like trying a case together and what it's like for you guys working together and everything. But tell me a little bit about, for everybody out there, who maybe doesn't know you. Everybody in Western PA certainly does. But, tell us about your practice and the kind of cases that you guys focus on. And then, we can kind of pivot into this medical malpractice verdict and trial that we're going to talk about today of a great outcome you got recently.
Well, Brendan, as you indicate, I've been in practice over 40 years in Pittsburgh, basically doing the gamut of personal injury work, although certainly the highest concentration is med mal. But, over the years, done everything from med mal, auto, aviation, products. And I don't know, JJ, I would say we're probably 80% med mal at this point. Is that your impression from your early months on the job?
Yeah, I would say that that's fair. Definitely the vast majority of this stuff, not even just the firm is handling, but myself as well is probably medical malpractice at this point, which is, it's a privilege, this early on in somebody's career, such as myself, to be able to be doing that kind of work so early on, for sure.
So
It is good. It is good fortune, JJ, I'll tell you, because, for better or worse, when I started out, the cases that I were working on, they were a rough bunch of cases with a lot of fleas on them. So, to get to start off with that, really higher caliber crop quality of cases, I personally think, I mean, while there's maybe pros of getting to cut your teeth on a lot of stinkers, I think it's probably best and most accelerative for your career to be starting where you are with the kind of cases that you want to be working on, rather than like, trying to trend up over years to get there.
Wait,
John, real
let
quick,
me
go ahead,
let me
John.
just comment real quickly. Putting aside the quality of the case, one of the things I think I really benefited from early on in my career, and I've always tried to do this with any associate who's worked in the office, is give them immediate sort of responsibility for certain cases so that they're the ones who are directly handling the case on a day-to-day basis. Because whether it's a complex case or a simple case, there are a lot of things to be learned just by virtue of the fact that you're the one having to take the calls from the client. You're the one having to respond to the opposing lawyer. You're the one having to do the frontline things, always knowing, however, that a senior person is in the background. But I've never had a setup where I said to an associate, "You're just going to work as my caddy for a few years, and then we're going to start to give you your own cases." So I've always been a great believer in that. It's the way I sort of started out, although mine was even more accelerated than that. I've often told this story to JJ and others. True story without any hyperbole, Brendan. I came out of a federal clerkship on a Friday. I started on a Monday in private practice, and on Thursday, the senior guy came into my office walking with a file under his arm, and he says to me, he says, "John, I forgot this case was on the trial list. Can you pick a jury tomorrow?" Uh, it was a case against U.S. Steel involving a barge accident on the Mon River. And, not knowing any better, I said, "Sure, I can do that." Well, I found out the client was in Chicago, didn't know the case was on the trial list either, ran over and got the case continued the Monday, and then, tried it for 4 days on my own. Um, never had a second seat. I ended up trying 8 or 9 cases by myself within the first 14 months that I was there. And I never had a second seat opportunity. I never had somebody come with me to jury selection or show me where to go. Needless to say, I learned a tremendous amount from sort of being thrown in. But, that's the extreme. I just think the notion of giving a young lawyer first line responsibility on certain cases is good for their development. Right, Jay?
Yeah, and I think that the tough part is, so it's obviously great that JJ gets into, a significant, medical negligence case this early. I mean, you're what, 1 year now, as an official attorney now, JJ, or are you 2?
Less.
I'm almost a year. So
Almost, right.
I licensed midway through October last year.
And
Yeah.
that was it was a nice convergence of, I had the opportunity to bring him in 4 months after he passed the bar. I had a case that was going to trial. And so that was a very nice, convenient opportunity.
Yeah, no, absolutely. And it's that, just getting into court, because that's kind of the curse when you go and you work at a firm, like, Gismondi and Associates, most of the cases are higher level, significant cases, and it's harder for a lot of those cases settle, when they are going to try. Obviously the more senior people, because of the stakes, are typically going to try them, so it's tough. And it's like, you don't want to go out of your way to bring dogs into the firm so that your associates can go try them, but at the same time, the thing that's going to distinguish any, I think, young lawyer coming up who wants to be a trial lawyer is actually trying cases, but it kind of creates that conundrum. So,
Well, in fairness, Brendan, JJ had that experience. I think 1 week after you passed the bar, he had a real dog of a jury trial that he got a pro se client, but he had the opportunity to try a jury trial in front of Judge Klein. So
it doesn't matter. JG, what was that case about?
Oh, so one thing to clarify, it wasn't a week, it was about a month, maybe it was about 3 weeks. But anyways, no, there's I think it's the civil lit section here, the ACBA. They have a program where, basically, if there are 2 pro se litigants, 1 of them coming out of arbitration, or I think even generally if they're just two pro se litigants on the GD docket to begin with, whatever, and they are interested in having counsel, both of them, then the ACBA or the civil lit section will put something out to members to see if there's any interest in somebody, representing them on a pro bono basis. And I got an email on one of these. It was actually Joe Frachel, who shares office space with us. And I saw the email, and I got up from my desk, went over to his office and asked him, hey, what's this all about? And he was like, oh yeah, you want to go try a case like next week? And I said, sure, why not? It was basically like a civil theft case. I ended up representing a guy who was suing somebody else for essentially theft of his property. So
was the thief represented, or was it just you versus an unrepresented thief?
No, so it was actually there were two attorneys. It was me and somebody else, another younger attorney from Petrogallo's office.
Okay.
And yeah, no, it was a great experience. It was about an afternoon's worth of testimony. It was a full day in terms of, picking the jury, some pretrial stuff with Judge Klein, and then testimony in the afternoon. And then we did closings the following morning. And, that was basically it.
And I didn't realize we were going to get a two for today, JJ. So how did that one turn out?
Well, I lost. I took the plaintiff,
Yeah.
The reason for that was I figured, well, I'm doing plaintiff's work. But no, we lost. Real tough case, considering that my client had a lot of crimes involving dishonesty in his past. So
what was the problem?
I kind of figured there was, in a he said, she said case, there wasn't a lot of chance that they were going to buy what my client was selling, but made the most of it. And actually one of the 6 jurors did want to give my guy some money, did sort of believe him on one of the things. So it was at least that.
Yeah, and unfortunately, those convictions were admissible under the PA rule.
Sure. Yeah, and credibility is everything. Which again, that's a great lesson. You get to see the reality of like, well, how bad are prior bad acts? Well, when it comes down to a credibility case, and they've got criminal acts that call into question their truthfulness, that's problematic. But look, great that you were offered that. You jump in. That's I tell everybody that's trying to try cases, that is priceless experience. So let's pivot to the case. We've already knocked out one case that we've talked about today. So we'll pivot to the next one, which is, this great verdict in this way outlying county. I was just saying to somebody the other day that it never ceases to amaze me when I still hear new counties in Pennsylvania that I've never heard of before. And I think this is yet another one. What county was this case in, guys?
Go ahead, Jay.
So it was in Mifflin County, it's southeast of Center County. So about an hour away or so, I want to say, from State College, going one direction. And I think coming from Harrisburg, it's about an hour away as well.
And is this one of these counties where like the county seat has one courtroom, one judge, and maybe they need visiting judges to handle cases kind of thing?
Yeah.
Yeah, that's basically it, I would say.
Yeah, I think the best description we heard, Brendan, it was amazing when we would call the court occasionally. Never met the judge really until the case was ready for trial, except on a couple of Zoom calls. But we were told by somebody in the courthouse this was only the second civil trial of any type that had gone to a jury in 12 years.
12 years.
12 years. Obviously, they do criminal trials, but so it was a small county, one judge and maybe a senior or a visiting judge, occasionally.
So I presume, John, you got the line from the judge, there hasn't been a verdict here in over 12 years. Well, there hasn't been a trial here in over 12 years.
Defense lawyer.
So whoever wants to jump into it, give us a summary of, from the story, medical, what was this case about? when it first comes into you, and then how, why is it that it winds up having to get tried in this county where cases are never tried?
Well, I'll give a brief overview, and I'm going to keep it really short, Brendan. Basically, what the case was about was a 60-ish-year-old woman with a delay in diagnosing an abdominal aortic aneurysm, which eventually ruptured. And ultimately, she died. Now, I always viewed the case in two halves, okay? The first half of the case was the failure to detect the AAA that we say showed up on a January 2017 CT scan that had been done as part of her medical clearance for knee surgery. We say the radiologist missed the AAA in 2017. No activity at all over the next 2.5 years. It goes completely undetected. So nobody's watching it. Nobody's doing periodic, surveillance imaging to see if it's growing because nobody knows it's there. Then comes the crisis day in September of 2019, 2.5 years later. She wakes up one day and she's got, sharp pain in her abdomen. She goes to the ER. They do a CT, and all of a sudden, there they discover the AAA. Now, by that time, it's over 7 centimeters. Back 2.5 years earlier, it was about 3 centimeters. So I call September of 2019 the crisis day because now it's diagnosed. It's diagnosed at the local community hospital in Mifflin County, where ironically she worked. And ironically, she worked as a radiology tech or transport aide. So that is then the crisis day. The community hospital tries as best they can to make arrangements to get her transferred to Geisinger into the hands of a vascular surgeon. She had arrived at the emergency room at 9:30 in the morning. The CT discovering the AAA was at 10:30 in the morning. She doesn't get transferred out until 3:30, arrives at Geisinger at 4:30, is not in the OR until 7:45 in the evening, and literally, as they are transporting her onto the table in the OR, she ruptures. She loses 32 units of blood, but miraculously, she does survive. So she ultimately is going to die 2.5 years later from complications of this. But I always viewed the case in two parts. The initial part was the case against the radiologist for failing to detect the AAA back in 2017, which had it been detected, they would have followed it periodically and intervened to do surgery when it reached 4.5, 5 centimeters. So that was the one half of the case. The other half of the case was the delay on what I would call crisis day in getting her transferred out, in getting her seen once she arrived on the ground at Geisinger, and then getting her into the ER. That was essentially the case, the radiology case, and then 2.5 years later, the what I'll call the crisis defendants once it was discovered.
I think you guys are good to talk about this, but did you resolve a part of the claim prior to this trial?
Yeah, and full disclosure, if anything I say, Dad, step in, because I wasn't a part of the case at this point. I wasn't even practicing. But no, the quote unquote crisis defendants did settle out of the case. When was it? It was over a year prior to trial, I think.
Yeah.
They settled out, all of the defendants involved in the delays, so to speak, on crisis day, the delays in transferring her, the delays in getting her into the OR once she was transferred to the hospital with the vascular surgeon. So the case that actually went to trial was against the radiologist and then his practice as well, as a vicarious liability defendant.
And
interestingly,
go ahead, John.
Brendan, I was going to say, it's interesting how lawyers look at things differently. I remember from early on in the case, I always looked at the case primarily as a radiology case because, the radiologist caused 2.5 years of delay. And I was prepared to say this in closing. I was going to have an illustration of a length of how many days are involved in 2.5 years of delay versus the 24-hour delay or 18-hour delay on the crisis day. But it was clear to me throughout discovery, the radiology defense lawyer out of Harrisburg, he always looked at the other guys as the main defendants. When the subject of mediation first came up, his position is, well, I'm just along for the ride here. Your main case is against these guys. And so he always looked at the case differently than I did. And so when we ultimately went to mediation, everybody was there. But we never got anything more than token offer from the radiologist. And the others stepped up, and, obviously a big part of the mediation was, hey, John, you're in Mifflin County. We got 7 figures and more on the table for you. That doesn't happen in Mifflin County. So, ultimately, I remember the dynamic, and Brendan, you've been there before in multi-party cases. You were there with a mediator going back and forth, and one party's just not doing anything. And finally, I said to the mediator, we had about 2 hours left in the day. I said, go tell those other guys, I'm interested in a joint tort. And so it sort of came together over the last 2 hours. And I went into the radiology defendant and said, look, this is what I have, and I'm telling you now, I'm going to do it. And so we did.
And I wanted to bring that up, that the later case resolved because,
Yes.
Especially for the, those listening, that are PA med mal practitioners, these, joint tort situations, when they develop late, you've already gotten certain expert reports and so forth, and the claims it's always a hot topic on listservs on, how, what are the implications of joint torting and how does that play out practically at trial? And we see it, go in all these different directions. Now, before we get into the details of how that played out, because that was quite and had big repercussions on the way your case carried out, just a couple sort of clarifying points. When she and John, I'm dull. What was the term you referred to the later case as, the crisis day?
I called it crisis day.
Okay, so the crisis day, what was the abdominal pain that she was presenting with that day? Was that related to the AAA, the aortic aneurysm?
Yeah, actually, it was right flank. It was right of center. It was right flank pain. She had some other signs. They immediately did a CT scan and immediately found it. And in the vernacular, that is called a symptomatic AAA. Prior to that, she had no symptoms. She had no awareness that she had a AAA for 2.5 years. But that day, with the acute onset of the symptoms and the imaging, it's a symptomatic AAA, which is immediately at risk for rupture, and it makes it an urgent situation.
It's sort of that she's finally reached that tipping point where now,
Yes.
The rubber has come to meet the road, or what is it? The chickens have come home to roost after all this time waiting.
Yeah.
And then the other question I had for you, just to understand how this trial played out, had the patient at the center of this, had she passed away prior to trial?
She did. A year prior, and just in a nutshell.
Actually,
Brendan,
I'm going to jump in. I think she had passed away a little over 2 years prior.
That may be. She survived the rupture, but she had so much blood loss. She had all this ischemic damage in her abdomen. She ended up with a colostomy, and then she ended up with fistulas. She spent the last year or several months on a feeding tube, and she ultimately died of a serious abdominal infection, which everybody agreed came from all the abdominal damage, which came from the rupture and the blood loss. So yes, she had passed away prior to trial.
So over the life cycle of the case, it converts from, standard medical negligence injury case into now survival and wrongful death claim.
Exactly.
Okay.
And by the way, after we took the joint toward, I remember coming back to the office, and I don't know if JJ wasn't here; he was still in law school. But I remember talking to Joe and some others in the office, and they said, he doesn't have a cross claim. Well, he filed, after we took the joint toward, he was given permission to file a cross claim. And we said, he'll never go out and get experts. Well, lo and behold, he went out because we said he's not going to get experts against Geisinger. He's in that area. He's a defense lawyer. Well, he went out and got experts against the emergency room doctor on crisis day, the vascular doctor at Geisinger, and he had his experts, and so he had viable claims to keep them in the case.
And, John, you're, on these listserv whenever this, it seems every few months, some permutation of a joint tort at trial rears its head, and it's always a hot topic. And you are always one of the, most knowledgeable people on the different, ways that it can play out. So if I understand in your case, you're so practically, at the time of this mediation, you have all of your different expert reports, and presumably so does all the defense, right?
Yes.
And typically, in these cases, you're going to have a standard of care expert as to the specific defendants, and you're going to need at least one expert on causation. But a lot of times, I'd imagine a case like this, your vascular surgery expert is also basically your main primary causation expert, right?
Yes.
But now, when you settle with the vascular surgeon, there's that idea that you don't necessarily want to call them because they've been critical of a now, non-party to the case, and that can create all sorts of problems. So, how did that play out practically for the two of you in this trial? You settle out the vascular component, that acute part of the case. Now we're going back in time to the ball drop of the radiologist. You obviously you have a radiology expert. What do you do? What sort of tactical decision do you make so far as that vascular surgery causation piece of it?
Well, I'm going to give you that, and then I'm going to let JJ talk about the big surprise. So you're exactly right. Once we settle, we're preparing, to go to trial. We're going to put in a case against the radiologist. We tell our vascular expert to stay at home because, he's got language in there that's critical of somebody that we settled with. And if he takes the stand, any judge is going to allow him to be cross-examined on that, even if I don't get into it in direct. So we tell him to stay at home. We're preparing to try the case under the assumption the radiologist is going to say, hey, I didn't miss anything on the imaging. Plus, these other guys were at fault. And as far as causation was concerned, Brendan, part of our plan was we would be reading in portions of the deposition testimony under oath, obviously, of the vascular surgeon that we sued at the time he was a party, because he gave testimony in there that was very helpful to us. He acknowledged that, hey, if this had been diagnosed 2 or 3 years earlier by the radiologist, any patient with a AAA that is, found but is not yet operable, you watch it at every 6 month or every year intervals. And when it goes from 3 centimeters to 4.5 or so, you schedule them from surgery at their convenience, so that it doesn't rupture. And, he gave us all of that testimony. As I said, she ultimately got to 7.5 centimeters. That would have been operated on long before. So, we have his testimony under oath from his deposition that we're going to read in. He's going to be a party to the case, because the other radiologist has kept him in on a cross claim. So we show up on the day to pick the jury, and JJ, take it up from there. What happens?
Yeah, and so just to put a finer point on it, I think a lot of the discussion, and obviously this was, driven by my dad, because obviously he knew, with all of his experience and everything, what to be concerned about going into this case. The concern obviously was, apportionment of fault, even if we get, the jury to agree with us that the standard of care was breached, it caused harm to the client and everything. There's certainly concern that the settling vascular surgeon, had also, the jury would find some fault against him as well, and apportion some fault there and, effectively reduce the verdict and recovery. So with that as the backdrop, we get to Mifflin County the day before trial, do some pre-trial stuff, check the courtroom, make sure our tech's gonna work, all of that stuff. We show up the next day for jury selection and to get the case underway. We go into sort of an auxiliary courtroom, different from the one where we're going to be doing selection because all the jurors are already in there. The judge wants to go over some pre-trial stuff with us. We're obviously there. The radiologist and his practice group's attorney is there. And then the vascular surgeon's attorney is also there. And lo and behold, it's for the very first time we find day the trial is supposed to begin, the radiologist defense lawyer is going to let out and is going to drop the claim against the vascular surgeon, which was very surprising and sort of mind-boggling to me at the time. It didn't really make sense, and it was something to me that sort of signaled, why would he be doing this? Like, why would he drop his cross claim that he has that could potentially reduce recovery against his client? I sort of was very suspicious that there was a very calculated tactical reason for him doing this. And I think the rest of the case, I think we can maybe talk about it a little bit, sort of evidence is why he did it.
Yeah, I mean, just to amplify, Brendan, yeah, I mean, I was shocked. I mean, we're in there, and he had to know he was going to do this. But he waited until literally minutes before the beginning of the trial. And obviously he was giving something up. As JJ said, once he dropped that claim, there is no apportionment for the jury to do. It's going to be an all or nothing. It's either going to be a defense verdict, which he was confident of, I think, or it was going to be 100% of the liability was going to rest on that radiologist. But he made the decision. And so now the vascular surgeon is out of the case. And it is strictly a radiology case. And at the time, very, very surprised as I was, and JJ and I talked about it, I didn't know at the time exactly why he did it. And to this day, he hasn't told me why he did it. But as things would evolve, I think I know what his tactical play was.
Yeah, there was clearly a rationale, and let's put a pin in that, and we'll cover that as it kind of comes up over the course of the trial. Okay. So
Sure.
now you're at trial. You're just out of curiosity, what's the jury selection process like out in Mifflin County in a tiny courthouse and so forth? You get to talk to them, or is it all judge led, or how'd that go?
Go ahead, Jay. I think we got to do it.
Yeah, no, they, put jurors in the box. They had everybody, literally all the jurors who were summoned were in the courtroom, just sort of sitting in the back. They put jurors in the box. And yeah, they did let us talk to them. It was basically attorney led, I would say.
Yeah, very open, Brendan. No private, no private one here. Judge is a good guy, nice guy, but he didn't really participate unless there was some objection. And the one thing I was disappointed with, we ended up with 8 or 9 men. I wanted women on that jury. She had lived with this colostomy and all the indignities and then a feeding tube. And, I had her on video. We had her on video, her deposition prior to her death. And, she was just a salt of the earth. But I was surprised. And I knew, and you've been through this, Brendan, when the whole panel walked in, there must have been 50 of them. It was overwhelmingly male. So I knew when we got down to 20 or 24 that we're going to be in play. It was overwhelmingly male, and that's how the jury ended up. I did not like that.
And so for me to just comment, again, obviously understand, more experience for sure and everything. To me, it actually wasn't much of a concern. And my thought process was, well, yes, obviously, uh, she had, passed away. She was the one who had been injured, primarily. She's the one who had the aneurysm, the rupture, and all of the complications. But I was thinking, well, the person who's here and that the jury is going to hear from directly live in person is her husband, who was the client at that point. There were a lot of guys on that panel. I think all of them were married. And I was sort of thinking that a lot of them were going to empathize with, our client, the husband who was still there. And I do think, and we can talk about this more, I do think how the verdict came out, I think it does sort of reflect that to some extent.
Were there particular questions that you were focused on getting answers to, to identify, problematic jurors, or on the flip side, jurors that might be reasonable for you?
Brendan, and you absolutely have been in this circumstance. One of the big concerns was, at least heading into this, the local community hospital was in play because they were the ones involved in crisis day and the delay in transfer. And as you can imagine, there's only one hospital in Mifflin County. And if it's not the largest employer, it's the second largest, employer. So that was a concern. And frankly, it was a concern to some extent, even after, the crisis day defendants were out of the case. Beyond that, I don't know, Jay, if you have any particular, I know I wanted women. I just did. But Jay, do you remember what other, I mean, we had a salt of the earth husband and wife. So, but any other thing that you were concerned about that we talked about?
Nothing, I don't think anything in particular. I know we were talking about this yesterday when we were sort of going over, what to expect today when we spoke to you, Brendan. And this is something that I actually think is interesting. And I actually think it could have been helpful to us. We don't know for certain. Two of the people who were potentially going to be on the jury had either personal experience or a family member who had an aortic aneurysm, an abdominal aortic aneurysm. The defense lawyer did use one of his preemptory strikes to get rid of one of them. I can't remember which one. I believe it was the person who said they had a family member who had passed away from one. But the other one was on the jury. And I thought at the time, like, that was a huge deal. I mean, having somebody in the deliberation room who's had that experience. Like I said, I think it was the one who said that he had previously had an aortic aneurysm. I thought that was, sort of a stroke of luck for us, having somebody who would be in that room who could sort of talk to the rest of the jurors and say, I had something similar, and I understand this is a very serious thing.
And can, corroborate, because now they're sort of the subject matter expert, what the different experts are saying, like what lines up and what doesn't based on their experience.
Mm-hmm.
Yeah. And hopefully would have the experience that our client never had the benefit of, and that is periodic monitoring, the watch for growth, which was the key of our case, that she was deprived of that opportunity. One other thing I would mention, Brendan, and I don't know if this is your feeling or not, but I mentioned this so many times to JJ heading into this case, mention it to others. And I've had other cases. I think when you're the plaintiff and the key or the heart of the case is they missed something on an imaging study, and particularly if it's an MRI or CT scan, as opposed to an X-ray, which is a little bit easier for a jury to understand and digest. I've always said to the average juror, that CT scan or MRI is just shades of gray. It doesn't mean anything. You could throw that up there and tell them that, there's XYZ there. How do they know whether that's true or not? And so I always had trepidation about going in and getting into the subtleties of imaging and saying, look, there's something there. And there's another expert who's going to say, there ain't nothing there. And as I said, it's all shades of gray. And that was a big, big concern, challenge, whatever. And if we'd been trying the case in Philadelphia County, it would have been the same concern. Just imaging cases present unique challenges.
So opening is the first time you're getting to, talk about, this delay, but a delay arising out of this, shades of gray imaging issue. What did you do in opening to try to make it more apparent to the jury why there was a clear, miss here?
Well, Jay, correct me if I'm wrong. I don't believe we used the CT scan in the opening.
That's my memory. Yeah, I don't believe that we did.
I didn't want to push the envelope because the defense lawyer he had made objections to many, many things. Let's just say that. I knew anything drew objections. I mean, when I wanted to put up a medical diagram in a deposition, just out of Gray's Anatomy, so to speak, objection. But what I tried to do, Brendan, was I spent a lot of time with the CT scan in the workup of the case, in the preparation. There were 67 slices in this CT scan, going down like a loaf of bread, down from basically about this level down right into the upper portions of the abdomen. And so knowing I spent a lot of time on my computer with the image, going through image by image by image, and I knew at what point the suspicion arose. And I got to tell you this, on 67 images, 67 slices of bread going down, boom, 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 boom. Where do you think the aneurysm showed up?
What, 67 or 1?
Slice number 67.
Yeah.
And it was only on 67, but it was the top of it. And I was really relying, and when I got into closing, ultimately going frame by frame. I mean, Brendan, it was like my Zapruder film. I'm not kidding you. I'm going through this thing and showing that change. It sort of started maybe on 66, and then I was toggling back and forth. See that, look at that, but that was a challenge, and the best preparation was to know the imaging study.
In opening, guys, how did you sort of frame the case as far as, I mean, I imagine it wasn't as, simplistic as, this is it, radiologist missed it or something. I mean, like how did you generally bring the issue to the jury? Did you talk about like the right way and then show the wrong way, or did you just get right into it? How do you feel that you communicated the error and then the implications of the error to the jury off the bat in opening?
Well, I think, and JJ, you can comment on this. I think, I did not use the image itself because I knew it would draw an objection with my commenting on what it did or didn't show when, I'm not a radiologist. But I said that we would be showing them, we would be having pictures, and we will show it to you. We will point it out. But the other thing I really spent time on, Brendan, was the implications of the miss. The fact that it would have been watched. And I said, at any time over this 2.5-year period, she could have had surgery. The implications of missing this meant that she never had the benefit of so-called surveillance imaging. And therefore, they never had an opportunity over 2.5 years that it could have been, repaired. That was a big part of the opening, getting them to understand that there was a long opportunity to take care of this. This was by no means a death sentence. These things, as long as you get them before they rupture, you're good. And they had 2.5 years to do that. So I emphasized the implications of missing it. Because they missed it, she never had the benefit of surveillance imaging. Jay, I don't know if you have any other, you sat there and...
Yeah, I'm trying to remember if we also sort of got into during the opening, uh, talking about how, this was not a scan that was done necessarily to look for a triple A. I don't think the defense was, going to put a lot of eggs in that basket, but they were going to make that argument, that this was, you know, just some sort of supposed, an incidental finding. But I think that we did stress that, maybe not necessarily an opening, but it definitely was a theme through the case, and something we brought out through the expert that, your job as a radiologist is to report the findings, whether it was something you were looking for or it isn't incidental. That's your job, when you're reading these images. And if it's there on the image, even if you weren't looking for it, you got to document it and put it in the report.
I'm guessing your case in chief was not tremendously long because you've gotten the latter part of the case out. It's a single, basically radiology case. What was your sort of the proof in your case in chief?
Yeah, obviously our radiology expert was key. We had an infectious disease doctor who we had videoed. No, nobody was really disputing that the infection came from all of the ischemic damage that led to her death. We had her on video, the decedent, obviously the husband live. JJ, we had the sister. You did her direct examination.
How'd you do the, I think, John, you had mentioned to me something about a Zoom CT.
Yeah, there was no trial tech company in Mifflin County. The closest one was in Harrisburg. And really, the only thing we needed was that CT scan. Okay.
Wait, so you did this case without a trial operator?
Well, JJ ran,
JJ was it.
Yeah, I was going to say, I was pulling double duty. I was both doing attorney work and doing...
Trust me, he was doing oral argument. He was showing up my exhibits when we needed him, and he was writing the memos at night. This guy was firing so many motions at us.
You better bonus this guy up at the end of the year properly, John.
This was just rather simple, and I would want to mention it. We put the expert on the stand with a laptop, and we had loaded the CT scan onto the laptop. Okay. We then just had the expert, and JJ hooked it up, to the screen so that whatever on his screen would be displayed. And but we had, when the expert was on the stand, JJ just opened up Zoom on the laptop and went to share file and opened up the CT scan, and then we had the expert. We had gone over that. We rehearsed this with him before and showed him the annotation tools that are available on Zoom, and it was great. He had a mouse with him on the stand. He could scroll through each slide. He could go over, draw a circle, draw an arrow, highlight. None of this is using the internet, so you're not at the mercy of the signal in the courtroom or anything. And it worked great. It was preloaded. Open up Zoom, just open it up, and use the annotation tools.
I like that because I'm sure you've had the experience where, you're using one of the trial operating companies. They've got the screen up there with the stylus, and half the times it seems like the stylus doesn't work, or they're like tapping it and nothing's happening, or how do I get this off? Whereas Zoom becomes much more sort of intuitive and easy to use in that regard. So that's pretty clever.
Yeah, and the fact that the expert's got the mouse right there next to him, he's got the facility. Now go here. Let me switch over to the different view, and so it worked out well.
Well, yeah, and so sort of the other thing that I think is important to keep in mind as well is that, unlike, maybe if you have with one of these, trial support companies, Precise, whatever, with, a tablet and a stylus that basically just allows the expert to annotate whatever, this was a little bit more than that, because what we did is actually gave the expert a computer so that he could open the CT scan in the, the radiology software, and he could basically demonstrate for the jury what it would be like him working at a workstation, going through, flipping through these images. So not just annotating, but he could literally just walk through every single bit of the CT. He could look at the different angles of the CT, the axial, the coronal, whatever we needed him to look at. And, admittedly, using Zoom was a bit of a way of jerry-rigging everything, but I mean, it worked, and I think that it definitely made a difference with the jury. We made a point of taking one of the TVs that was on a cart. There were a couple of TVs in the courtroom that were mounted, and there was one on a cart. Everything was hooked up to all three TVs, so three different displays. But the one on the cart, we made a point of, bringing really close to the jury box, as close as we could, so they could still see the expert. But the scan was right there in front of them on this 50, 60-inch TV, so they could see things really, really clearly.
I think we sort of overlook sometimes like that degree of credibility that you just talked about, where that idea that, look, this is how a radiologist would have done it. This is the actual software that they would have used to open this up, and here is exactly how it would look, and here is me scrolling through the images. And rather than having, say, static images, which would be a very common way to do it, and you've got slide 1, slide 2, your operator's calling it up. So I think that's a really cool idea to keep in mind for future. I think there's also something too, when you're talking about Zoom, that, that is an application that a lot of people are familiar with. And I think
Yes.
when you add that, like, people know what this is, they're used to it. I would imagine that it's just even easier for them to process. And then with the annotations within that, I could see how that was really effective. On the flip side, how did how did they approach it with the defense radiologist showing imaging? Did they do it similarly, or did they do something different?
They had a tech guy from their Harrisburg office, who was operating things. And frankly, I don't know. I thought ours was a little smoother because our guy was in control of everything.
Well, so actually, I do think, if my memory, no, I think whenever the defendant radiologist was up on the stand, he did, like our expert, have a computer where he was going through the images himself. So he was doing something similar. Now, I don't think that they had annotation
They didn't
capability,
annotate anything.
so there was that difference. But he was up there sort of like our expert, going through with the software, flipping through images and all of that of the CT. And while we're on it, this reminds me, and this is one of those things that jumped out to me immediately. No idea if it did actually have an impact on the case, and it's certainly nothing that would have come out on the transcript of the testimony. But I remember distinctly, as the defendant radiologist was up there demonstrating for the jury, telling them, this is what I would do, this is what I would have done to review this CT. He was flying through these images. And I just sort of thought there to myself, whenever I saw him doing this, obviously he's not testifying, but they're seeing everything he's doing. And this whole case is about, you need to, review the image, make sure you're looking for these incidental findings. And it, to me, just sort of screamed, it seems like he maybe just was sort of going through this way too quickly. Now, of course, do we know whether the jury was thinking that in their heads? I don't know. But like I said, it's one of those things that would never be reflected in the transcript. But I remember it was like a motion picture. He was flying through these images so fast whenever he was saying and explained to the jury, this is what I do whenever I flip through these images. And it's surprising to me. I wonder if that is something that he just sort of did on the fly, and the defense lawyer's watching him and saying, oh crap, this is not good.
Why are you going so fast?
Yeah,
Brent,
I mean,
that's interesting, because that made more of an impression on JJ than it did me, probably because you and I have seen radiologists who have explained, hey, here's my routine in reviewing a CT. I go to these images first, and I go, then I go to this view, and I do this. But it really caught his attention, and maybe it caught the jury's attention about, hey, he's going through this, pretty quickly.
And I suspect that that's the way that it would probably have struck most jurors who haven't sat through. Like, I've sat through many times, my dad showing me imaging stuff, and he's just like up and down, like, lightning. And I'm like, hold on a second. I don't even understand, like, where we are on the screen. But I'll bet you that did connect with a lot of the jurors. I don't want to, so I want to go back to what we had put a pin in, though, sort of the heart attack moment of, middle of the trial. So there was an interesting aspect of this that we sort of touched on earlier, and I think it fits into this, very one of those very stressful moments of being a trial lawyer. So you guys opted not to call a vascular surgeon, right?
Yes.
So now it's our burden on the plaintiff side, not only to show standard of care violation, you got to show, causation, be it direct or increased risk of harm. Question is, can a radiologist alone do that? You had mentioned earlier you were thinking, oh, well, we'll just read in testimony from the prior defendant vascular surgeon, and that would maybe get us there as well. What actually happened practically, and then at the close of your case in chief?
Yes, and I'll let JJ comment on this. Certainly, he did a lot of the work on this. So, Brendan, when it came time, as part of our case in chief, obviously, as our radiologist is on the stand, he made objections, says he's only here as a standard of care. He's not here on causation, and we got into a whole battle about that. But our radiologist did testify that he knows as a radiologist that if a AAA is found, the practice is they return to radiology periodically for surveillance imaging. And we were able to get that much in through the radiologist. Although he fought like hell to keep that out, saying he's not qualified to testify to that.
And also, just to add, I think we did also get some testimony from him that, if as size increases, so does the risk of rupture. I think that was really important as well.
That's that's directly on point to increased risk of harm, which I'm sure you ended up arguing, right?
Yeah. And I mean, our whole argument for why he was allowed to testify to that is because as a radiologist, he has to understand, that as size increases, so does the risk of rupture, because he has to know whether or in what situations he has to pick up the phone and make a call, and be able to identify those emergency situations and distinguish those from the ones where, oh, okay, this is something that just needs to be referred to a vascular surgeon for monitoring.
All right, so here's what happens, Brendan. Now I'm going to cue up the key issue and the focal point of the legal debate in the case. So after our radiologist testifies, we get up, we're going to read in those juicy passages that we have of the defendant, ex-defendant vascular surgeon who gives us good testimony on causation. Well, lo and behold, he objects, says you can't read it in. First, he said you don't have a report and all this. I said, I don't need a report. His deposition. You were there at his deposition. We said Rule 4020 that you can read in a medical deposition, And we argued for 2 hours. The judge took it under advisement overnight. And we came in the next morning, and I got to tell you, I was shocked. The judge says you can't read it. And his ruling, it wasn't real clear. He said, well, I think this is in the nature of expert testimony. And he said, I'm used to having experts here qualified in front of me. Well, meanwhile, the deposition, I'd gone through his qualifications in the beginning of. I said, Judge, I can read that in as well. But I don't want to get it. The bottom line is he would not let us read that. And now at the time, and as we were arguing this, the light went off, and JJ and I said, that's why he let out the vascular surgeon. He let him out because he was going to make this argument. We can't read in his testimony. Now, I still think that was a hell of a trade-off because he was giving up any allocation of fault, to another party, divvying up another piece of the pie. But I believe that's why he did it. So now, all we are left with is the testimony. I never expected to be in this position. I said, we got the vascular surgeon, we'll read it in. So all we are left with on causation is the testimony of the radiologist and ultimately whether or not we could make out an increased risk of harm, get by a non-suit based on his testimony. Do you need an expert on increased risk of harm? What must they say? biggest argument in the case, the whole case, that was the tipping point, if you will. It kept JJ and me up until literally 2:00, responding to motions. You take it from there, JJ, on increased risk of harm. That's your
Yeah.
bailiwick these days. So what our argument was.
Yeah, and so just to provide a little bit more background, I don't know about you. I think I did mention this to you. The light went off in my head about, oh crap, he's going to move for a non-suit. The day before the judge ruled that we couldn't play these portions of the vascular surgeon's testimony, the light first went off for me whenever we went up to sidebar and he was objecting to us reading those portions in. Because I then at that point made the connection, oh crap, that is the whole reason he didn't want this guy here. Because I think
He's
he
smarter than I
recognized that
am,
if he
Brendan.
kept him in the case and he was going to be here live, the judge was probably going to let us read them in because he could then go ahead and cross-examine him again live.
Yeah.
And so the gamble he took essentially was, admittedly, a big gamble, and he lost. But I think his thought was, I'm pretty confident I can get this thrown out on a non-suit. I don't have to worry about a jury apportioning anything to me because they're not going to get the case. But so anyways, I mean, on increased risk of harm, our argument essentially boiled down to a couple of things. One, the testimony that we got in through the radiologist it was sufficient, for sort of the reasons we were just discussing before. He did give us testimony that says as size increases, so does the risk of rupture. And that was testimony that was heard by the jury. It wasn't objected to, any of that. And then also we sort of were making a novel argument, and I think this is really where the judge kind of hung his hat when he eventually ruled. We sort of said that this was a situation where it was so obvious that the failure to diagnose the aneurysm led to the rupture, that this isn't something that you need an expert to get up there and, testify and explain this stuff to the jury. It's patently obvious what happened here by failing to diagnose the aneurysm.
But by the way, Brendan, the argument being, if you don't detect it, you don't know it's there, you can't watch it, you can't monitor, you can't do surveillance of it. And if the whole purpose of that is to intervene, and here she never had it, and she did go on to rupture, how can you say that the failure to detect it didn't at least increase the risk? But we got into the whole debate. Do you need an expert to say that? And go ahead, Jay, on the increased risk and whether or not, what does the charge on increased risk under Pennsylvania really require?
So, what's interesting is that I think a lot of times we sometimes forget that this is really how increased risk works. It's more than just proving the increased risk. Proving increased risk doesn't automatically get you a verdict in your favor if you convince the jury that the risk was increased. The jury instruction that is, based on the case law, Hamel v. Bashline, which establishes increased risk in Pennsylvania, very clearly says that proof of increased risk just provides the factual basis for the jury, if they accept that the risk was increased, for them to go another step further and determine and find factual cause. And that was essentially our argument. We had presented evidence of increased risk, and debating the minutia of, did we actually need an expert to say that or not? But regardless, if we did or we didn't, we had sufficient testimony. It was for the jury to decide whether or not they thought that failure to detect this aneurysm was in fact factual cause in this case.
And the heart of it, Brendan, and this was their whole post-trial motion, you need a vascular surgeon to say in this case, her rupture came about from, the failure to detect. We said, we have a radiologist. They said, well, that's not expert testimony. He's not qualified to talk about vascular surgery practices and whatever. And we said, well, we don't even really need an expert. The cause charge in Pennsylvania does reference Lattanzi versus Silvestrini, which says if it's so obvious, but their response was, oh, that's fall down cases. That's automobile accident cases. There's no med mal case.
Of course,
what's
interesting.
Go ahead.
I was going to say, what's interesting about that, though, of course, is that the comments to the factual cause instruction for med mal cases explicitly references the Silvestrini opinion, this Lattanzi versus Silvestrini opinion. and does it just says right in the comments, there are some cases where, the negligence is so obvious that you don't need an expert testimony on causation. So I think, and we argued it, and the judge ultimately, that's where he hung his hat, I think, was on our argument about, Latanzi versus Silvestrini. The defense, really tried to push, that was just a case involving regular personal injury, so to speak, which I always think is interesting because when you really think about it, med mal is ultimately personal injury. It's maybe not auto, not fall down, whatever. But yeah, I think the judge hung his hat there, and he recognized that the standard, I think it was, for what constitutes obvious is either immediately like apparent or the natural and probable result of the negligence. And we said, well, this is absolutely a natural probable result of not detecting an aortic aneurysm. If you don't detect it, you can't treat it. And if you can't treat it, it is going to eventually rupture. It's exactly what you would expect to happen if you don't detect the aneurysm.
Although, Brendan, I got to tell you, you know how your heart beats out of your chest when you're waiting for a verdict?
Oh, yeah.
We went on with this argument for well over an hour, hour and a half. And he said he needed a break, and he said he was going to come back and rule. Okay, I vividly remember. He was out well over 45 minutes. And as that's dragging on, I'm saying to JJ, boy, because the whole case hangs in the balance. And all of this stuff was new to him. He had never, tried a med mal case or anything like that, didn't know any of this stuff. And Jay, do you remember sitting in the courtroom? I remember waiting and waiting, and it kept going on and on and on. And he finally came back out and gave his ruling. And, he said, I'm going to let it go forward.
Yeah. Big sigh of relief. I just had a very similar, very legitimate, motion for directed verdict, at the close of our case in chief a couple weeks ago. And that was a sickening feeling when you're like, we could lose this right now. I mean, that does not feel good.
I remember sitting there thinking, is all of this going to come down to this? And I was so upset about that ruling about not letting us read in the vascular. And I said, is it all going to fall down, come crashing down?
Yeah.
But
you get by the skin of your teeth, and
you get into the defense case, and there was one key witness, obviously their expert. And I got to tell you, before we get to closing or whatever, I made this remark to JJ. Rarely have I had such separation between the quality of the expert report and the quality of the expert on the stand. I thought the report was very pedestrian. Basically it was, hey, sometimes, people miss stuff. Because everybody knew in retrospect, yes, it was there. But, this was very subtle. People miss stuff. 30% of these are missed. Motion to eliminate on that. So now the guy shows up in the courtroom. And we had seen him in the hotel. There's only one hotel to stay at.
Yeah, right.
I said, that's him. He gets up there, very distinguished looking, former chief of radiology at Bethesda Naval Hospital, former radiologist for the United States Congress, former radiology for 2 terms in the White House.
Wow.
And I sort of knew some of this stuff from his resume, but when he got up there, a military guy, very, I would use him. Very, and I remember sitting there as he's going through those images, and, and he says, well, that's, I can understand how he would think that's a loop of bow, whatever. And I remember saying, how am I going to cross-examine this guy? Shades of gray. Jay, what do you remember? Then I cross-examined him, and I did make a little bit of headway.
Yeah, and I mean, I think you had to tread very lightly.
Very narrow.
Yeah, you had to tread very lightly. I do remember you definitely surprised him at one point. I will distinctly remember this. I don't remember exactly what it was that you had asked him about. It was something about the anatomy within the peritoneal cavity where different anatomical bodies are located, and it sort of took him by surprise, and he sort of did like a whistle of some kind, and then like agreed with you. I think the cross was handled very well. I mean, I think it established some credibility with the jury, what we were saying. And I do also remember right before you got done with your cross, you sort of looked over your notes. I think you were thinking about asking some more questions. And I think I knew where you were going to go with the questions, but you decided not to ask them. And I think it was important because it allowed us to make, I think, a really key argument in the closing.
Yeah, I didn't remember that moment. JJ, I remember after the lunch break telling me, this guy at one point when I said, isn't thus and such true, and something about the anatomy image, he sort of went, ooh, like this guy knows what he's talking about. I don't remember that, but he saw it, and the witness was very close to the jurors. Hopefully they saw it, but I stayed very, very narrow, and I stayed away from one question. And, I always tell my my students, Brendan, in trial advocacy, and when they see me on the street, if they remember one metaphor that I've always used with them on cross-examination about the one question too many, I say to them, and I've been saying it, I'm in my 40th year teaching it, and I'd said it in year one. I said, cross-examination is like going grocery shopping. You are gathering the ingredients, okay? Closing argument is when you bake the cake, okay? If you try to bake the cake during the cross, a good witness may just, take your feet out from under you. So I did not ask one more question because I knew it was going to be the cornerstone of my closing argument.
And you don't want him taking you for a ride and, pulling that keystone argument out from you for closing.
You got it.
Yeah.
Exactly.
So
I made a couple of limited points. You're right about that. Yeah. And, and I did not go, that one more question.
So pivot that to closing, couple of things. One, how do you take those ingredients and, use that with the question you didn't ask to make your compelling liability argument? And then how do you argue these kind of damages, way out in Mifflin County, about as rural a county as you can get?
So let me say this. I in many ways, I told JJ before this, I thought this was going to be one of the most challenging closings I had ever done because of this whole thing about shades of gray and this guy saying no and my guy saying yes. And I really by the way, Brendan, I got to tell you, we closed in this case. Closing arguments started after lunch on a Friday.
Good times.
The jury got the case at 20 to 5 in the evening. Okay.
Oh, God.
No, that's when they came back.
No, they came back at 20 after 5. But whatever.
You're late on a Friday.
And Brendan, I had told JJ probably midway through Thursday, I said, you know where we're headed on this case? And I had asked the judge to hold him. We don't do that, but in any event. So as I approached the closing planning for it, I knew that image was going to be key. And I sort of rehearsed with JJ. I said, JJ, a lot of closing arguments about rhythm. I don't use any notes during closing arguments. I don't use notes during openings. I said, but I got to keep the rhythm going, but yet seamlessly use this image. So we had the computer set up on a lectern right near where I could reach it and still be sort of, and I said, this has to work smoothly. You got to get this stuff set up. I don't want
pressure, JJ.
And he did.
And I got to be honest, it was more than just setting it up. Because using the CT, which was I think was critical to again show the jurors again. This time, instead of having our expert doing it, it was having
Me doing it and me not screwing up and knowing well enough how to go through the axial view, the coronal view, whatever.
yeah,
And
it was there was a lot of time spent making sure that he understood how to use the software. Let's
Yeah,
just
yeah.
yeah, and use
Yeah.
it seamlessly. And by the way, I don't remember this so much, but you talk about on the fly. One of the things I was concerned about, they had said in their defense case, well, this only showed up on image 67, out of 67. And I was just go ahead, JJ, because you remind me of just on the fly. I made a
yeah.
remark.
This was basically the one of the very last things that you left them with, I think, on the liability argument during
Well,
closing.
while I was talking about the CT scan.
No, yeah, but it was definitely near the end. I think there were a couple of other things you said after, but it was definitely near the end. It was whenever we were talking definitely about this, the aneurysm. It's clear on this one image, and you brought up how the defense's whole point was, it would only appears on the one slice. It's the only spot that you can see the aneurysm on. So their argument's sort of trying to be, well, this is a reasonable miss. And I guess the thing you thought of on the fly was something to the effect of, they are saying that it only comes up on one image. That strikes me as sort of being like you catching the robber at the bank with the gun and the mask on only one still of the image and him saying, well, that's all you got me on. To which I would say, isn't that enough?
Yeah,
I mean, it's like, why do you need any more?
Yeah, that's great. No, that's a great on the fly.
I do remember using. I said it's like a bank with multiple, and I purposely I did have it on the fly. I said surveillance cameras, and I used the word surveillance, for surveillance imaging. I said surveillance cameras, and like the bank robber with the gun and mask saying, "Well, you only got me on one of the cameras,"
That's but I mean, I think that's a great argument for people in general, because that happens a lot of times on these incidental cases. Is it does only show up on one or two slides, and that's a logical defense argument, but a great analogy to counter it. I love it.
So here was the point, the focal point of the closing. What I never ask in cross-examination, a CT scan, the bread slices like this are the axial view. And that's where the image, the aneurysm showed up best. But there are other views, like the coronal view. Okay. Now, their whole argument was that it was reasonable to interpret what we were calling a AAA as a loop of bowel. Okay. Their defendant said that, their expert said that. Well, when my expert was on the stand, my expert had said the following. He said, look, I don't really think this is a loop of bowel. I mean, it just bumps out here. It's like a bulge on a tire. But
and he said it was also in line with everything else that everybody agreed was the aorta. So it followed the path essentially.
Yeah.
But then he said, my expert said, well, I don't think that's a loop of bowel. But he said, if you had any doubt about that, he said, all you have to do is switch over and look at the axial views.
Coronal.
The slices going this way.
The coronal views.
Coronal views. Okay, I'm sorry. Coronal views. And he said, there you can follow, you can tell that's not a loop of bowel. He gave the reason X, Y, Z. It's obvious. So their defendant got up, never, ever mentioned the coronal views. Their expert got up, and in his direct, I'm noticing, he never said a word about the coronal views. And that's the point where I said, well, look, I could cross-examine this guy and say, doctor, isn't it true if you go to the coronal views, that disabuse you of any notion that this is bowel? I didn't do it.
Because he'll muddy it up.
Whatever. And I fashioned basically the whole liability closing. In fact, I remember explicitly saying to the jury, if you forget everything I said in opening, if you forget everything I said in closing, if you forget everything that my expert said and their expert said about this CT scan, I want you to remember one word, and that is coronal. And I wrote it out, I recall. And from there, I said, this is why I want you to remember this word. Okay. And I really was rolling the dice on the one thing my guy said, they never rebutted. And to me, it was apparent that they were staying away from it. They heard my guy say it. He had said it in his report. Their guy takes the stand, doesn't rebut it or respond to it, and their expert doesn't. That really struck me.
Well, I think that's such a great instinct there. You know, it's not always, the key thing isn't what they said. It's what they haven't said, you know, and why, you know, why are they doing that? And sometimes you could gloss over that or not really, because it's not sticking out to you, but you guys picked up on, well, what aren't they addressing? That kind of seems like a significant point, and then capitalized on it. And I also love that idea, John, of like, you know, if you remember just one thing, you know, like really focusing their attention on the most important thing there, is great. And after a long trial and late on a Friday afternoon, you know, that's always the thing people perk up. Well, listen to the one important thing I should pay attention to. So talk to me briefly, you know, as we start to wrap up here, how did you frame damages and why, you know, a rural jury should give any money to this, you know, gentleman of a woman whose wife passed away?
Jay, go ahead. You sat there and listened and we talked about it, the damages.
Yeah, I think a couple of things. One, like we talked about before, they were salt of the earth people. They obviously heard from the wife through a deposition of her that had been taken prior to her passing. And, you know, I think we framed it as, you know, as far as her, she endured essentially what amounted to 3 years of hell. I mean, she never got better. She only got worse. You know, we talked a lot about how, you know, one of the points we talked about, and I think the way you phrased it, Dad, was there was a point where she was really, really hopeful, and so was her husband, that this, you know, colostomy bag that she had to have because she lost, you know, half of her bowel. You know, there was real hope that the colostomy was going to be able to get reversed. The husband talked a lot about how they were so happy when they were going to the doctor that day to, you know, to go in for the appointment, to, you know, confirm that that was something that they could do. I think they took her into surgery eventually to reverse the colostomy, and they ultimately couldn't. There was too much more ischemic damage to her bowel, and they at that point determined that they had to do a full ileostomy that was going to be permanent. And keep in mind, before all of this, the husband and both the wife, through her deposition, had testified and explained to the jury how much she hated the thing. She was so self-conscious about it. And I remember the husband talking about, I think, how it killed him whenever he saw his wife waking up and she was like asking like, how'd it go? Is it gone? And it just crushed him knowing that it wasn't. I mean, I think the way you phrased it during the closing was that, you know, hope turned into agony and just total defeat. She was gutted, and, you know, things only got worse for her from there. And then ultimately, you know, she has a almost month-long hospitalization before she ultimately dies as a result of this infection.
Brendan, let me mention something, and I've said this to JJ in context of other cases he's working on and thinking about trial of those cases. In fact, we just had this conversation yesterday. I've said to him that it's always helpful when it comes to pain and suffering and things like that. Get somebody else to talk about it other than the plaintiff.
Totally.
Get a friend, a coworker, or whatever. And I have to say, in this case, JJ did a great job, got her sister, worked with her, prepared her, and then he did the direct examination of her. You know, her talking about what her sister went through. And she was
not just that, also what she observed the husband going through after the fact, which I think was really key, you know, because obviously the husband could be that third third party talking about the wife's pain and suffering, what she went through. We needed somebody to talk about what they observed the husband going through after the fact. And I think, I think he was very nonchalant sort of about his own pain and suffering. And I mean, he was obviously crying and everything, when he was on the stand talking about his wife, and, talked about how hard it was, to be in there testifying and sort of reliving all of this. But when the sister of the wife got up there, she made it really clear he wasn't the same guy anymore. I think she testified. We asked her, what do you see him doing these days? And she said, I don't think he really does much of anything at all. I think he just sits at home and sort of scrolls and looks at pictures of, my sister. And he sits in their living room with her empty chair. And I remember telling you, Dad, that was something, that empty chair line was something to really hit home on during the closing. I thought it was such a visceral encapsulation of the loss for him, a physical manifestation of the loss that you could point to and look at, and it's an empty chair, but it was representative of everything that he had lost.
I think that's great and poignant. And I think it's such a good point about, having other people talk about somebody else's loss than them. It just never comes off right when they try to do it themselves. You have a husband and wife. I tell the husband, you talk about her, she talks about you, really. And as far as you're concerned, you're not focusing on yourself. And I think actually people that relieves a lot of the burden on people, like that. How am I going to describe my injuries or my damages? Like, you don't have to. We're going to have other people do that. So, with all those great, damage pieces that you worked out, how did the verdict break down?
It was basically half for her, on her pain and suffering, and half for him on consortium. It was pretty equal. Which, I had no idea what to expect damage wise in Mifflin County. By the way, there was never an offer during trial. It never changed. And there was never any approach. Hey, are you interested? Do you want to talk? Anything like that? And, I still remember, Brendan, just that jury going out on a Friday evening. And, there we are waiting in the law library, and the law library was about the size of your office. And that verdict, we got the word, to go in. It was a great experience. You're there with
your kiddo. Yeah, that's awesome. And you guys are battling. I'm thinking of you guys up late at night. If I was doing that with one of my boys, they'd probably kill me. But it's a cool idea, and I love it. I love thinking about the fact that you guys got to do that together. Get that great outcome that you fought so hard for, especially when there were those moments where you thought, you might have lost it on a legal technicality.
Yeah.
So gents, that's an awesome story, an awesome outcome, great battle, which must be the record-setting verdict of Mifflin County now, right? And until they try another one in 15 years from now.
I think if we got a tenth of that, it would be the record verdict. But it really was for me a defining experience to go in with your son. And gee whiz, you have no idea. He's 4 months out of into practice after the bar, and to watch him, sort of go toe to toe in the arguments. That there were so many arguments at sidebar and elsewhere, and then just the game planning together. His and then his examination in the courtroom was it was really it was something to see, and it was it was very fortuitous because, Brendan, as you said, there's so few cases relatively that are trying. And I remember telling JJ on the way back, we drove back that night, it was 10:30 at night. I said, Jay, I said, you're going to look back on this. You may not appreciate it now. I said, you are going to look back on this 10 years from now, 20 years from now, and realize what a unique opportunity it was for a young lawyer right after passing the bar to have the opportunity to go in and be part of, trying a med mal case from start to finish and being able to see it and participate that early on. It just lined up timing wise. I mean, this case was supposed to go to trial a year earlier. It got continued for various reasons. And so it just lined up. And, I'm sure he learned a tremendous amount. So it was a great experience from that standpoint.
And JJ, not to pile on the, you're so lucky bandwagon here, but I think there's also something to be said, in addition to, the experience trying with your dad, hard fought medical negligence case. There's a lot to be said, I think, of, being part of a trial that results in a significant verdict. Because I remember I tried so many cases when I first started out, and I just lost and lost and lost. And I knew it was possible, but it wasn't until I got my first good verdict that it was like something clicked. Like it was actually real. It can happen now. And so getting to see the reality of that, just hearing about your dad's verdicts over the years is different than being a part of it and seeing the reality of it. And that, everyday people from a county you've never even heard of could cause a verdict like that. So really cool stuff, guys. So I think that's a good ending point. Fascinating stuff on a lot of different levels. I learned a lot. Congratulations to both of you, John, JJ, from Law Office John Gismondi and Associates. I appreciate your guys' time today. Everybody knows where they can find you guys. Thanks for doing this. And I'm sure I'll be interviewing you guys again soon with some other big verdict that you get. But thanks for doing this, guys.
Pleasure, Brendan. Thank you.
Absolutely. Thanks, Brendan.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.